Hi there, and welcome to another edition of the Kessler Law Firm podcast. I'm your host, Michael Kessler, board certified criminal trial lawyer operating primarily out of Florida's Treasure Coast. I have some rules that I try to guide my work by. Rule number one is never prosecute. I never have, I never will. You see, the duty of the prosecutor is to seek justice, not merely to convict. So says the American Bar Association in Rule 3 1.2c of its standards for criminal justice. The problem is, not enough prosecutors believe this. Instead of being a place to find justice, all too often the courtroom is an arena where trial lawyers are gladiators and where winning isn't everything, it's the only thing. Prosecutors are backed by all of the power and resources of the government. No matter how much money an accused person has to spend on his or her defense, the prosecution has more. Police and sheriff's departments, teams of lawyers and support staff, and crime labs staffed with forensic scientists work together against the accused. The presumption of innocence is there to protect you, but the law does not enforce itself. Courage in the face of sometimes overwhelming odds is required if one is to defend. In the conversations that follow, I will take you on a walk through the halls of justice. It will not always be pretty. Occasionally, it might even be frightening. I have found in the American criminal justice system a nearly endless supply of harmless fun, despite the dangers. I hope you enjoy it as much as I have. Let me tell you about one case in particular to illustrate my point. I was asked to defend a young man who was charged by the government with kidnapping and rape. His former girlfriend had accused him. He was no angel. In fact, he was not only a convicted felon already, he had only just the year before been released from prison. If convicted of these charges, he was going to be sent back there for the rest of his life. I started by reading the police report. This is what the accuser said happened. She said, "We got into an argument at child support court. He didn't want to pay. We argued in the hallway, we argued in the elevator, and he got loud and angry. When we were right next to the metal detectors on the first floor, he yelled and he threatened me. I walked right across the hall to the domestic violence clerk's office and applied for a restraining order. I got the paperwork, took my child home, put him in the playpen in my house, and I walked out through the garage to my mailbox at the end of my driveway. When I came back into the garage, there he was. He was hiding there and he grabbed me. He dragged me back into the house. He put me up on the kitchen island, on the kitchen counter. He held a gun on me, a pistol, in my own kitchen, and he raped me. When I met with this client, I expected him to claim that she consented. He surprised me with a defense that seemed doomed to fail. Here's what he said happened. I was never there. Inside, I groaned. Mistaken identity? The jury will never believe that. No, somebody's lying. It is the duty of the jury to presume that this man was innocent. If he was, then the woman had to be the one lying. I began to investigate her claims. She had claimed that the argument began at the courthouse. It was loud, she had said. It was by the metal detectors, she had said. I went to the courthouse and asked the courthouse security officers to pull, for my review, all of the security videos from the courthouse that day. Let's see if they looked as if they'd been arguing. After viewing every single video, I was surprised, but not by what I had seen. Instead, by what I hadn't seen. My client was not on film anywhere, not from any camera. Zip, nada, zilch. It was as if he wasn't even there. His accuser was nowhere to be seen either. Things that make you go, My next stop was the domestic violence clerk's office. By the way, it was not across the hall from the metal detectors. In fact, it was not even in the same building. Across the hall from the metal detectors at that time was the law library. The domestic violence clerk's offices were in the annex building next door. The annex building had no metal detectors. The domestic violence clerk searched their records and found no record of her ever applying for a restraining order. Not that day, not the next day, not ever. Across the hall from the domestic violence clerks, I found the child support clerks. I went through those records too. Funny thing, my client was not in court on the day she had claimed. Neither was she. The child support case she had filed against him had not even been in court for 6 months. And even then, he wasn't there because he had never been served with papers. There was no indication in the court file that he even knew a child support case existed. I think I then knew who was the liar. I went back to the police reports. Was there any physical evidence? No. Easy stuff first. His fingerprints were not found in her home or garage. No physical evidence was found where she claimed the attack occurred. There was no physical evidence discovered by any nurse or doctor. Let me be clear about this at the risk of being vulgar. The sex crimes examination done at the hospital revealed no physical evidence of any violent sexual activity. No sperm, no hairs belonging to anyone other than her, no bruising, no tearing, none of the things that those medical professionals are used to looking for in this kind of an examination. There was also no forensic evidence on the kitchen island. Again, not only no fingerprints, but no stray pubic hairs, no pubic hairs of hers, no sperm, no nothing. Then I took her deposition. In her deposition, she told us, and by us I mean the prosecutor and me, that my client, who, by the way, was 5 feet tall, never put his gun down. His feet, she said, never left the floor. Despite his feet not leaving the floor and him holding the gun on her with his right hand, she said that he was able to reach into his left hand, pull out a packet containing a sealed condom, open the packet, take out the condom, put the condom on, and sexually assault her, all without putting the gun down and all without his feet leaving the floor. The kitchen island would have to have been up to his chest. Somebody is lying. The truth seemed clear to me. After the witness left the deposition, I spoke with the prosecutor, a veteran trial lawyer herself. I carefully went over everything I had found in the courthouse videos, in the clerk's records, in the records from the hospital, in the records from the crime scene police. I went over with her everything I had found and everything I had sought and not found. I expected the prosecutor, whose obligation was to do justice, to tell me she was dismissing the charges. Not exactly. Instead, what she told me was, I'm not going to be the one to tell this woman she wasn't raped. Let the jury tell her. My client was forced to go to trial and to trust a jury of 6 strangers, none of whom were his peers, to see the truth for what it was. He had no one on his side but me. This time, having me on his side and the truth I brought with me was enough. Accusers sometimes lie. I never prosecute. I defend. Thank you for spending a few minutes with me on the Kessler Law Firm podcast. I hope wherever you found us on YouTube or whatever other source of podcasts you have, that you'll hit like and join us so you don't miss a single episode of the Kessler Law Firm podcast. And if you're interested in our services, you can find us at www.kesslerlawfirm.com. And you can email me directly if you like. My email is michaelfreakinkessler@gmail.com. Thanks again and have a great day.